Hello, everyone. My name is Valerie Robbins. I am the Assistant Director of Student and Industry Connections. I'd like to welcome you to Lawyers for the Creative Arts, the Artist Legal Toolkit. This is our third event for Your Network, Your Narrative, a new 2-week career experiences designed to help you discover career paths, build your network, and hear directly from industry professionals. The next upcoming event will be our virtual career exploration trek, which I will let my colleague Basanti share with you quickly.
Good afternoon, everyone. My name is Basanti Miller. I am also an Assistant Director of Student and Industry Connections here in the Career Center. And we will be hosting what I just put in the link is actually a link to all other upcoming events. And one of the first ones that you'll see is the virtual career exploration trek with Nakia Nichelle. She runs her own branding and PR company. And she is really excited to talk to you more about open internships that she is seeking to fill. She's also going to have 3 other of her staff members there to talk to students about the roles that they do and ways that they can get involved with her or just become interested in the industry. So please check that out and register. Back to you, Val.
Thank you, Basanti. Just a few housekeeping notes before we get started. We'd love to see your beautiful faces, but completely understand if you can't keep your cameras on. Please make sure that you keep your mics muted unless myself, Basanti, or TJ is asking you to come off mute to explain more about your question. And then I'd like to pass it on to DePaul alumni TJ Kliebhan, Chair of the Lawyers for Creative Arts Board, and also Senior Counsel at Gordon Rees Scully Mansukhani. Take it away.
Hey everyone. My name is TJ Kliebhan. I am an attorney at Gordon Rees, like Valerie said. I've been working as an attorney in the world of entertainment law for about 6 years now. I work with clients that are mostly musicians. Music is what I'm passionate about, but I work with musicians, folks in the film industry, models, social media influencers, basically anyone who touches the entertainment world. I work with them. I'm here on behalf of the Lawyers for the Creative Arts, like Valerie said. That's an organization that I volunteer for. The Lawyers for the Creative Arts provides free and reduced costs legal services to anyone who qualifies in the state of Illinois. Not just Chicago, but Illinois as a whole. If you find yourself in need of pro bono, free or reduced cost legal services, you should check out the Lawyers for the Creative Arts website. It's law-arts.org. Or you can send me a message and we can see, what the Lawyers for the Creative Arts can do for you. The organization, if you qualify, will work to match you, in your case, with an attorney like me who can spend some time helping you out. With that being said, today our presentation, Law Smarts 101, is, kind of a presentation targeted for creatives. And we're going to be talking about ways in which you can protect your art in your business. Okay. So without further ado, um, intellectual property laws, that's how you protect your art, your creativity. Um, it's a way to protect art that or things that maybe aren't necessarily tangible. I want you to think about like music, stories, images, right? These are the types of things that intellectual property protects. We created intellectual property law because we wanted to protect these things, and like traditional property law that we had, things that protect like your house or your car, they weren't really covering intellectual property. So that's kind of why this stuff was created. These are the three main vehicles that I think of for protecting intellectual property. They're patents, copyrights, and trademarks. A patent, right? So I'm just going to read it. An exclusive right granted for an invention. I really want you guys to associate patents with inventors, okay? People creating basically new ways of doing things. This presentation is really more geared towards creatives, and I really associate patents more with like tech or industry. So we're really not going to get into patents today. But just for your purposes, think about patents, think about inventors or inventions, okay? Primarily, what we're going to be talking about today are copyrights and trademarks. If you're a creative, those are going to be your more powerful assets. Um, Copyrights, I'm just going to read here, a legal term used to describe the rights that creators have over literary and artistic works. Um, I want you to guys to associate copyrights with things you create, okay? A copyright exists to protect things you create. Trademarks are different, okay? So a trademark is a sign capable of distinguishing the goods or services of one enterprise from those of another enterprise. What does that mean? I want you guys to think about trademarks or associate trademarks with brands. Okay, trademarks are how you protect your brand, or how you protect something that's associated with your brand. Okay. Um, a great thing to think about with trademarks, right, is trademarks, they their primary function, and I'm going to get into this more later, but like trademarks, their primary function is to protect consumers in the marketplace, okay, to protect all of us. That's kind of the idea, right? With the idea being, as like an example, right? If I decided tomorrow to wake up and start a restaurant and call it Burger King, right? If you were a customer and walked into my restaurant, there's probably a good chance that you're going to expect that I'm going to serve the Whopper and that you're going to be treated like how you normally treat when you walk into a Burger King, right? You're going to expect to see Burger King branding. If you don't see that stuff, you're going to be like, where am I? We think that's bad. We don't want people to be able to do that. And so that's what a trademark kind of exists to prevent and protect, right? So again, copyrights, I want you to think about how those protect things that you create. Trademarks, those protect your brand or things that are associated with your brand. So we're going to start by jumping into copyright law, okay? Um, so copyrights, they kind of, right, they protect the expression of the idea itself. Um, Here's what I want to say about this. So to think about this simply, right? You can't simply just like protect an idea that's in your head and there's nothing like tangible associated with it. Like as an example, right? If when Stan Lee created Superman, right? He could protect, the entire idea of a superhero, right? I mean, think about how much that would cripple creativity. Think about all the great art that we would have missed out on because Stan Lee owns the idea, or he had a copyright for the idea of a superhero, right? Um, we think that would be bad. We don't want that to happen. So, you can't just protect an idea. There has to be something tangible, whether that's a drawing or a name or like a written story, an idea. Like it can't just be an idea. There has to be something tangible there. Um, in order for the government to give you a copyright, it has to be kind of this bottom half of my slide, okay? It has to be an original idea fixed in a tangible medium. And what that means, we're going to get into it, okay? It's kind of legalese, but that's the most important thing. You have this original idea that's fixed in a tangible medium, okay? Um, and that's all you need for copyright protection, okay? So that's all you got to show to the government. I'm going to go on kind of like a tangent here and just say there's a lot of tall tales out there about how to get copyrights and what they are. And after attending this presentation, you will never fall for them. I think a lot of them are kind of hangover from like the pre-internet era. Thankfully we live in the internet era where searching this stuff is really simple, but we didn't always have the internet, right? And I think stories like this just got spread around. But like there are old stories out there that you sometimes hear repeated, where like if you put a CD in the mail or a drawing in the mail and then mail it to yourself, that automatically gets you a copyright. Like, no, that's not true. Like that's a lie. If somebody tells you that, they don't know what they're talking about, don't listen to them. All you need to get a copyright is exactly what I say in the bottom half of this slide, okay? You need an original work that you fix in a tangible medium. That's it, okay? So what does that kind of mean? Let's get into it more, okay? Let's start with that first element of what you need to get a copyright, and that's the originality part, right? I think this is pretty straightforward. Don't steal from people. Like you can't steal from people and get copyrights. They're not going to let you do that. You can try to do that, but it's going to end up bad news for you. Trust me. Yeah, if you want copyright protection, your idea has to be original. Okay. So this is really simple, but all of a sudden now it's not, and that's because of AI. So let's just get into this a little bit, okay? Um, we all know, right? There's all this technology out there now where you can put in your half-baked idea, right? Your song that's not complete, 3 lines of your poem, the first few paragraphs of your story. You can just put that into AI, and AI will finish it for you, right? Um, can you copyright that? Let's talk about it, okay? It's kind of a long story. The Copyright Office, the United States Copyright Office, the people who give copyrights, right, to people, they have always been obsessed with this idea of human authorship, okay? If we go like all the way back to the 1800s, what intellectual property lawyers were fighting about back then, right, was can you copyright a photograph? Because, you know, is the human that took that photograph, are they the author, or is it the camera? Is it just the machine that created the photograph, right? Um, Again, like, right, they're obsessed with this idea of human authorship. Don't worry, you can copyright photographs. But at the time, that was the debate, right? Like, is there human authorship here? This debate hasn't stopped. Like, as recently as 2014, there was a case where I don't even know how, but somehow a monkey got a hold of a camera and took a photo. And the guy tried to copyright it. Or, I don't know the guys, whoever. Somebody tried to copyright that photo. And the Copyright Office said, no, you can't copyright a photo that a monkey took because there's no human authorship there. We're not going to give the monkey copyright protection again because of this lack of human authorship. Okay. Um, Now, kind of transitioning to AI, right? AI isn't new. AI has been in computers forever. AI has been in video games basically forever. What's changed, right, is AI has gotten a whole lot better, especially in the last like 2 years. But I just say all this to say like the government isn't like new to this, all right? They're not, and they're not new to the idea of AI, okay? They've actually addressed AI as early as 1978. And basically what the government said for AI back all the way back in 1978 is whatever AI is creating, there's no human authorship there, no copyrights. Okay. Um, Ever since 1978, tons of people and businesses have tried to challenge this idea. The government has never wavered, never wavered. They have always stuck by that principle, no human authorship, no copyright. So I want to take that all up to like the lay of the land now, okay, and talk to you about like how this works practically. Um, let's go very back to, what I said at the beginning, right? You take your 5 lines of a poem, put it into AI, have AI finish your poem. Can you copyright that? So here's how that's going to work. If go to the US Copyright Office and ask for like an official copyright, here's what's going to happen. First, you're going to have to tell the US Copyright Office that AI was used to create your full poem. Okay? So that's what you're first going to have to do. And here's how it's going to work. You can actually still get a copyright for that poem. But what's going to happen is you are only allowed to copyright the part that you created. You are only allowed to copyright, the part that had that human authorship. Okay. The rest of that poem that AI spit out for you, that is not copyrightable. And so how that works practically, right, is if you did that, and then the next day I also did the same thing, right? I wrote a poem and I wanted AI to finish it for me, and it gave me the same lines that it gave you, right? You can't come attack me, you can't say, hey, I had a copyright in this because that portion that AI gave you, it can give to anyone, okay? It's not copyrightable. You can only copyright what you created, your own human authorship. Kind of works the same way with a song or really any other piece of art. There are some wrinkles to this, okay? That I'm not giving you the full universe here, but this is not an AI discussion, so I'm just going to leave it at that. If there are further questions, at the end, we can kind of address those as they come up. But that's really all I want to say about originality and how that kind of interacts with AI today. Um, there are a lot of different types of works you can copyright. Literary works, right? Books, musical works, songs, dramatic works, your plays, pantomimes, choreographical works, sculptures, pictures, motion pictures, right? So movies, other audiovisual work, and that's pretty broad, but think about, short films, video games, YouTube videos, really any of that stuff can be copyrightable. Sound recordings, that's just another word for basically, the recordings of songs, music, architecture. And sound recordings too, I want to touch on that a little bit because that can mean anything. It can be music, it can be stand-up comedy, it can be bird calls, it can be nature sounds, podcasts, TV static, really anything. Anything that you record. We've got more, works of authorship here. Just think about what I said on that first copyright slide, right? Anything that can be original and can be fixed in a tangible medium kind of has, an element of creativity to it. It works. It's going to fit for copyrights. I mean, maps, magazines, dance choreography, right? I mean, it can be pretty broad. It can be pretty broad. Okay, so. All right, just refreshing us, right? Copyright. What do you need to get one? You need originality and you need it to be fixed in a tangible medium, right? That's the other element that we need. So let's talk about what fixed in a tangible medium means, because that's another kind of chunk of legalese. I just think that this is a fancy way to say recorded in something reproducible. Recorded in something reproducible. That's all I think that means. Um, there's a few things on this slide. I'll let you read them yourself. But where it says in blue right there, capable of being reproduced. That's like the most important thing with fixed in a tangible medium. So, you can fix a lot of things in a tangible medium, right? And I have them listed there kind of at the bottom. Computer files, CDs, paper, like anything, okay? I said at the top of this, right, that primarily my work is in music, and I'm going to be giving probably a lot of music related examples today, including right now. Um, so there's a lot of ways to do this fixed in a tangible medium, right? I think the most traditional, right, if you're a songwriter, you go to a studio, you cut your song, right? They record it either like if it's an old school studio, like literally on a tape, or if it's like a newer digital studio, right? They will create a computer file for you. That song has now been fixed in a tangible medium and you have a copyright. Okay. You have a copyright now. Um, and before I get deeper, like you have a copyright. Okay. Notice I didn't say anything about like going to the government and registering anything. Okay. We're going to get into that more, like why you do that, but you don't need to go to the government and register anything to actually get some copyright protection. You have a copyright the second that original work is fixed in a tangible medium, right? So the second you record that song in the studio and it's on that tape or that computer file, you have a copyright. If you're a bedroom musician and you get an idea and you record a demo for it on your iPhone, that iPhone just created a computer file for you. You have fixed that song in a tangible medium. You have a copyright. If you haven't even recorded the song yet, but you've written the lyrics on your notebook paper and you've written some chords on there, even if you've only just done one of those things, just the chords or just the like the chord progression or just the lyrics, you have a copyright there. It was fixed in a tangible medium. It was written on paper in your notebook. It's really as simple as that. And I know it sounds crazy, but it really is as simple as that. So there are some things that we exclude from copyright protection because they would make society a nightmare. You can't copyright titles or short phrases. You can't copyright facts. We can't have people like owning facts and not letting other people use facts, right? I mean, it would make society a nightmare. Shapes, symbols, functional objects. Like So you can get some trademark protections with functional objects, like, a creative, if like, okay, I'm thinking about that vase, right? Obviously, you can make like an artsy vase. There are vases that are in museums, right? Those can get copyright protection and designs, but like a bit, just your basic functional vase, your basic functional t-shirt, right? Like those things cannot be copyright protected. But again, I'm going to get into that a little bit, for just other reasons. Works authored by the US government, those cannot be copyrighted. Yeah, those are the basic ones that can't be copyrighted. All right, ownership. Um, so copyrights are only handed out to authors of creative works. Um, this can be very simple if you work by yourself. This can be very complicated if you don't. If you write all the songs by yourself and you record them by yourself, simple, right? You're the only copyright owner. But what if you play in a band? Or what if you work on a movie script with like a partner? Or something like that, right? Like what if you have creative collaborators, right? Here's what's going to happen. If you have no paperwork between you and your creative collaborators that says who owns what or how these percentages are split up, the law defaults to making those creative pursuits joint works. And a joint work means everyone owns everything equally. Everyone, not only do they own it equally, but they have a right to the profits from, that copyright equally. So if you don't want that, you need to get a contract and you need to be careful about what that contract says. Um, there are often situations, right, where you don't want to split ownership. And that's where something like a work for hire will come in, a work for hire agreement, which, I'll let you read. That's the bottom half of this slide. But let me give an example of where that could be relevant. If you're a songwriter and you wrote this great song and you're like, I know this song is great and I want it to be my song, but I know I've got this part in here and it needs a saxophone and you don't know how to play the saxophone. Okay. Here's how you use a work for hire. You're going to write a work for hire agreement, or maybe have a good lawyer write a work for hire agreement for you. And that work for hire agreement is going to say, hello, Mr. Saxophone player, you're going to come in and you're going to record in the studio on my song. I'm going to give you 500 bucks or, however much you want to give them. And you are going to take that 500 bucks and that's it. You will get no copyright ownership of the song. Okay. That is basically what a work for hire says. Okay. Now, the example I just gave you is kind of like how a work for hire would agreement would work with like an independent contractor, right? Just some random saxophone player. But if you work for a company, I promise you they're using work for hires too. Probably in your employment agreement, but even if you don't have an employment agreement, the law just kind of defaults to favoring employers. If you're on this call and you are, a marketing major, let's just say you get hired by Walmart, okay? And you start creating creative ads for Walmart, okay? You do not own those ads, okay? Everything you create, everything you make for Walmart as an employee is the property of Walmart, okay? Just by the nature of that relationship, everything you do basically falls into the work for hire space. And it can work like that whether or not you're an actual employee. There are often times where businesses, like I'll just use Walmart again, but like let's say Walmart HQ, you walk in there and maybe on the main floor they've got a big terrace, right? And they want a piece of art there. It wouldn't be surprising for Walmart to use a work for hire agreement to commission another artist to build a sculpture or, a piece of, a painting, something like that, right? That they can put in their main terrace. And that work for hire is going to say, you don't own this piece of art. This art is going to be a property of Walmart, and we're going to give you $1,000 for it or whatever, right? Um, so work for hires are very common. They're very strong tools, not just for corporations though, for artists too. So just keep that in mind. They're really important. If you're signing a work for hire, you're not going to own anything. So just keep that in mind. But you can use them too. Okay. Once you have your copyright, um, there are certain things you can do with that copyrighted work that no one else can do. These rights are exclusive to just the copyright holder, and they're powerful. These rights are powerful because this is how you use that copyright to make yourself money. Um, the copyright, the copyright owner is the only one who can copy or reproduce that work. So if you're a painter, right, and you usually don't just sell the original, right, of your painting. You make copies of it. So, people that maybe don't have a whole lot of money can still get your art and put it in their house, right? Any right to those copies, or maybe like you want to put your painting on a t-shirt and sell that, right? Any copying of that image, you are the only one that are allowed to do that. You're the only one that's allowed to create derivative works, okay? Derivative works can mean a lot of different things. Let's go to the music industry, a remix, right? Everyone knows what a remix is. The copyright holder is the only one that is allowed to let other people remix their song and put it out. You're the only one that's allowed to distribute the work. And what I mean by that, again, maybe you want to be the only one that puts the work on, Bandcamp or on Spotify or something like that. You get to be in charge of where your work appears, both publicly, um, either like to perform it, right? If it's a song, maybe, or like a movie. Um, yeah, to perform it or to display it, right? If it's art. Basically, you control how your art appears in public, right? Um, and you control how other people can create derivative works of that art. That's basically what I'm trying to say here. Those are all good things. Transferring your copyrights. So yeah, you can do it. It's typically called copyright assignment. Um, Copyright assignment. You're okay, so here I'm just going to give an example for this because that's the easiest way. You're seeing like a lot more stories like this now, where it's like Britney Spears sells the rights to her catalog for $200 million, right? That is an example of a copyright assignment, okay? Britney Spears is taking the rights to her songs and assigning them or selling them, giving them away to some company, right? That is a copyright assignment. Another way you can transfer your copyrights are with a licensing deal, okay? The key difference between a licensing deal and an assignment, right, is you still own your copyrights when you license them away. You're saying, Walmart, I am giving you a license to put my song in your commercial, right? You don't own the song, but you have a license to put it in your commercial. That's really all a license is. It'll just the right to control and use that copyright will revert back to you, usually after a certain amount of time. Another way to transfer copyright rights, is with a will. Um, so I don't want to get into too much detail here, but basically just for your purposes, guys, I want you to know that your copyrights are going to last beyond your life. For most situations, the copyrights will last for your entire life plus 70 years after you pass away. So if you write the next great American novel or a big hit song, your spouse and your kids are probably going to be interested in those copyrights, all right? And you're probably going to want to write a will that gives them the rights to those copyrights. So yes, you can give them away by will. The last one is boring, operation of law. Basically what this means is if you die without a will, a court is allowed to give away your copyrights to your heirs. So that's, basically how that works. Another thing is like if you're in massive amounts of debt it's possible for a court to say, we're going to garnish the wages from your copyrights in order to pay off your debt. Two situations that are fairly rare. So it's not something that you should think about too much. But if you have some copyrights that are making some money, please write a will before you die. Otherwise, you're going to turn into the Prince estate and all your kids are going to be fighting over it, and it gets real ugly. So try to avoid that. All right, switching gears here. Going to trademarks now, right? So let's go back to the top, right? Copyrights, they protect those creative creations that you have, right? A trademark is different. Trademark protects a word or phrase or logo basically that identifies your brand, okay? I'm just going to read the definition. Any word, name, symbol, or device used to distinguish a business's goods and services from, their other companies' goods and services, right? Um, Sometimes trademarks are really simple. I think everyone knows what Nike is, right? Or like the Nike swoosh. That's like the gold standard for a trademark. Like you can't confuse Nike with anything else. I'm not aware of anything called Nike other than the brand, right? Um, that's an example of like a really distinct trademark, a really strong trademark. Not all trademarks are that strong, and sometimes the like trademarks require what's called secondary meaning for them to be distinct, okay? Or for them to, I guess, have value in the eyes of the government, okay? Um, we're going to get into this more on some slides, but basically, if you're trying to show or like what secondary meaning is you're showing that something else, right? A word, or a logo or whatever is becoming associated with your brand. That's like the best way I can describe it. Once that word is becoming associated with your brand, it's being given a secondary meaning. It's creating its own secondary meaning. And this is going to this is going to make more sense as this goes on, but like I'm going to try to give an example on the top to really illustrate this idea of secondary meaning, okay? Everyone here knows what a window is. It lets light in. You open it up and you get a breath of fresh air. That's pretty much what people associate with that word. Um, when Microsoft first rolled out, their computer software, it was called Windows. And nobody really associated that word Windows with computers. So the word didn't really have any secondary meaning yet. If Microsoft tried to register a trademark for the word Windows in association with computers right away, the government would have told them no. The government would have said this word doesn't have any secondary meaning. No one associates the word Windows with computers or with your brand. So sometimes secondary meanings, right, they need to be developed over time. As computers became more common, as operating systems became more common, and people became more aware of the Microsoft brand and how Windows was associated with that, right? That word Windows kind of achieved its own secondary meaning, right? And now Microsoft is able to trademark that word Windows. That's kind of the best example I can give of it off the top of my head, but I'm going to give more examples of kind of how secondary meaning works. I already talked about this a little bit, but let's go into more detail, right? Like, why do trademarks matter? I kind of said this at the top, right, with Burger King, but trademarks, they exist to protect the marketplace, right? I really said consumers. I think that's the primary protection is consumers, but it protects businesses too. Um, we want to reward businesses for building brands. We want to reward businesses for quality control of their products. We want to reward businesses for, you know, being good, essentially. I don't know how else to say it. Being good. We want businesses to be able to build with confidence that no one is going to come in and start a company with the exact same name as them and steal all their goodwill and their customers, right? That would be bad for business. It would create chaos in the marketplace if any Joe Schmo could start a burger company named McDonald's or Burger King, right? So we want businesses to feel like there is incentive or reward for building their businesses. Okay. That's very important. But I think what's more important is how trademarks protect consumers for the reasons that I've already ranted about, right? We want people to be able to go into shops or to interact with companies and know who they're interacting with, to be able to interact with them confidently, to be able to understand what expectations are. Okay. A big thing when you file a trademark, right? Basically, the first thing that anyone who is reviewing your trademark that works for the government is going to think about is, is this going to create confusion in the marketplace? If I allow this trademark to exist, is this going to get confused with something else, right? Um, that's like that's the biggest thing. Okay. Um, so that's what we want trademarks to exist to prevent, right? We don't want confusion in the marketplace. You can protect a lot of different things with trademarks. I've already kind of said a few of them. Logos, like the Nike swoosh, right? A word, I think everyone understands that, right? Like the word Google is trademarked. You can't start a search engine called, something similar to Google. It'll create too much confusion. Slogans like all states, you're in good hands, or Nike's just do it. Product packaging. This is huge. If you create consumer goods, this is huge. You really want to trademark that name on product packaging. There's a reason why every single item of clothing you buy has the name of the source for it on the tag. It's for trademark purposes, okay? There's a reason why all your packages from Amazon get sent to you with Amazon tape on them in Amazon boxes. Or if, you own I don't know, a gas station and you order, Coca-Cola, it's going to come in, Coca-Cola, branded packaging. This is all to establish the source, right? Where the goods came from and to protect those trademarks. Um, Product designs, right? Like the design of how a unique like chair looks or a Ferrari car looks, that is trademarkable. Sounds, this is a fun one. So sounds, they are hard to get trademarks for, but you can do it. My example in there is the NBC chimes, but I have like more fun ones. If you go see a movie that got put out by MGM Studios, the first thing you'll see is that lion roaring right at the beginning of the picture, right? That sound, believe it or not, is trademarked. For my hip hop or dance fans in the chat here, or in the meeting here, if you are familiar with what a producer tag is, right? When a song starts and you hear DJ Khaled or something like that, right? That is a trademarkable sound. Um, so sounds can be powerful trademarks. They definitely identify people. You hear that DJ Khaled scream, you know this is a DJ Khaled song, right? You can even identify colors, scents. I mean, these are really powerful tools. If you can really show that something is associated with your brand, you can really corner the market for something. Okay, so this chart, I think people can inherently read it and understand it, but I'm still going to kind of go through it. There are certain trademarks. Trademarks are like kind of evaluated on a spectrum. And I kind of talked about this, like, I was raving about how distinct Nike's trademark is, right? That is a super distinct trademark. And then there's kind of the opposite end of the spectrum where something is really generic, right? If you're so generic, the government will not give you trademark protection. If your company is carpet cleaning company, like there's a million companies that do that. It's way too generic. No one will like find that to be distinct or unique. You're not getting a trademark for that. Okay. Um, there are obviously better names, for stuff though. And that's when, let's go back to that idea of secondary meaning, right? That's where secondary meaning starts coming into play. So let's talk about like a descriptive mark, like American Airlines, okay? Um, it's descriptive in that it's an airline that is, headquartered in America. They are obviously not the only airline that is headquartered in America, right? They're obviously not the only airline that has flights around America. So it's not the most distinct trademark in the world, right? What American Airlines is going to have to do, and what they did, right, is they, really put themselves out there in the marketplace, marketed that name, and basically upped the awareness, upped the secondary meaning of the phrase American Airlines. They got it to be associated with their brand. That's what you have to do if your trademark is merely descriptive, right, and less distinct. Another example of this is like Holiday Inn, right? Um, Holiday Inn is not the only hotel that's open on a holiday. So, that's not a very distinct trademark. It's descriptive, right? It tells you what they do, but it doesn't really tell you much else. So if Holiday Inn, started their company today and filed for a trademark tomorrow, it's probably going to be denied because there is no secondary meaning to that trademark yet, right? It's a brand new company. People aren't going to be aware of them. But once they start advertising more, using the name Holiday Inn in association with their chain of hotels, right? Once the public awareness kind of picks up a little bit, then that phrase Holiday Inn is going to have more secondary meaning, and they can apply for their trademark, and they have a good chance of getting it, right? Um, Kind of the middle tier here, like a suggestive mark. Um, Burger King's a good example, right? Because I'm pretty sure, like, you hear the name Burger King, you probably suspect, or it suggests, right? I can probably get a burger there, among other things, right? These are marks that are probably still going to need some secondary meaning, but it's certainly better than American Airlines, right? uh, Descriptive to suggestive, it's kind of a blurry line. I don't think it makes much of a difference. You're gonna need to show more secondary meaning, basically. Um, Once we get to arbitrary marks, we're getting to marks that are more distinct. Um, when I think of arbitrary marks, I think of a mark that is unique for the space, I guess is how I would put this. So my example there, right, is Apple. Apple as a company, they don't sell apples. They sell computers, among other things, right? They sell a million other things. They sell phones. They sell a ton of stuff. They're a tech company, right? So it's certainly a unique name in that space. You wouldn't associate apples with tech, right? And there are plenty of other marks that we can think of that are like this, right? Amazon. Amazon doesn't sell or really is associated with like a tropical ecosystem, right? They have a online marketplace. Um, Shell Oil, right? They sell gas. They're not really associated with like a sea creature or crustacean or something like that, right? It's an arbitrary mark, right? That's my best way of kind of explaining it. Arbitrary marks are better. They're considered more distinct. And they're better because they need less or sometimes no secondary meaning you don't need to show any secondary meaning to get a trademark issued by the government. Um, Not all the time, but again, they're marks that are stronger than suggestive marks or descriptive marks. The best marks out there are considered fanciful. They're the most distinct. Nike, like I said, Haagen-Dazs. There is no confusion about what Haagen-Dazs is. Everyone knows they hear that phrase, they associate it with ice cream. It's very clean. Um, Other ones I can think of Google. That one's pretty fanciful, right? So basically, the way I just want to sum this up is the more unique, the more distinct your trademark or what you're trying to trademark, the more likely it is that the government will grant you a trademark, the more likely it is that the government will want to see less secondary meaning. If your trademark is more generic or less distinctive, the government is going to want to see more and more evidence that basically your mark has secondary meaning, right? That you have a space in this market. Okay. Um, this is all like this isn't clean, all right? Sorry guys. Like that's just kind of how the law works. There isn't like a hard and fast rule with this. This can be different, depending on which trademark examiner is looking at your trademark, right? This is kind of like a sliding scale, but nothing is clean, right? You want to argue your mark isn't suggestive, it's arbitrary, therefore you need to show less, a secondary meaning. That's going to be a tough argument to make. Like, it's kind of a beauty is in the eye of the beholder sort of situation, right? These are guidelines. They're not exactly the most hard and fast rules, but that's kind of how a trademark works and how that spectrum of distinctiveness can work.
Yeah. Thank you, TJ. We
Yeah.
have about 15 minutes left and have some great questions in the chat. So I'm just going to call on a few people. It's around copywriting, the previous slides that you spoke about before.
Sure.
So I'm going to have someone come off mute.
Yeah.
Francis, can you share a little bit more about the question that you asked in the chat?
Yeah. So I'm a filmmaker. Can you hear me?
I can hear you, Francis.
Um, I I do a lot of work with archival footage.
Hmm.
Um, and it's been explained to me before, but I kind of like get lost sometimes. So in a transformative work, I'm transforming the footage into a different context by making it and I post it onto YouTube. How do I go about crediting without getting in any trouble?
It's a good question. And I'm gonna peel it and kind of twist it a little bit. Just because you credit something doesn't mean you can legally use it, right? So let me go back to whatever the heck I was talking about here, right? You're creating a derivative work, is what you're doing, okay? And like I said, just because you're doing that and crediting them doesn't mean it's technically legal, okay? So how you credit them, I don't think is as important as like whether or not it's legal. Whether so you're working with archival footage, right? Which means it's very old. Some of it might be in the public domain, in which case that means you can do whatever you want with it. You can make derivative works of it. That those works they don't have copyright protection anymore. Some of it might be old, but still protected by copyright protection, right? Because what did I say, right? Life of the author plus 70 years. So even though something is old, it was made in the 40s or whatever, that person might have lived to 19, 80, and then they might have died, and that we're still within 70 years, right? Like so that's a hard thing for me to answer without knowing what exactly you're looking at. I mean, by all means, credit them because people like that, and it makes them less angry. But just because you're using it doesn't like and crediting them doesn't mean you can legally use it. Does that answer your question?
Yeah, yeah, pretty much. I guess if you do want to use something that has exclusive rights and it still has a copyright,
Hmm.
do you have to go to the source and say, "Hey, can I do I have?" And then do you
License
have
it.
to like write? You have to license it. Okay. And then the
Hmm.
second question is that like something that we can like a resource we can find online and just go about it ourselves, or is that something we have to go through with a lawyer?
Yeah, no, that's not something you need a lawyer to do. Some people are easier to track down than others, right? What's so great about the world today is a lot of people are on social media, and sometimes they even put their manager's contact information in social media. So there's ways that you can do that yourself. Um, you can charge somebody can charge you whatever they want for a license, right? You're also risking, there's also a little bit of a risk here, right? Because you're putting yourself on their radar, right? I'm a lawyer, so I'm never going to tell you to just do something illegal, right? I can't do that. But here's what I'll say the reality of something like this is, let's say you were doing this and you got caught, all right? What's going to happen is the owner of that copyright is going to send you a cease and desist, and they are going to say, take it down. Okay. And you should comply with that. And if, I mean, they might not even send that to you. They might just send it to YouTube or wherever you're hosting the video, right? And tell them to take it down, and then they will. In 99% of these scenarios, right? And don't rely on this because you could be the 1%, right? But in most scenarios, that'll be the end of it. Okay. They just want it taken down. But there are, if you're in that 1%, right, where the footage that you create ends up popping off and getting a lot of views and generating revenue for it, maybe a significant amount of revenue, right? Um, there's a chance that they're going to come to you and they might say something different. They might say, "Hey, we love what you're doing with this. Let's work out a licensing deal and, we're going to split the money that you've made so far and the money you're going to make in the future on this," right? There's a lot of different variables with how this stuff works. Um, and it's really just it's so dependent on the copyright owner because there are some people that like, I mean, to give you a different example, like rap music, okay? A lot of rap music is built on soul samples. People that created music from the 70s and 80s, there's the 60s, right? Um, and the beats, right, are kind of built on those soul samples, right? Some old soul guys love rap music and they will give you licenses and they'll give it to you cheap. Some guys think that's the work of the devil and hate it and they will never give you a license for it. And in fact, they will work very hard to make sure that gets completely scrubbed from the internet and taken down. So like, it's hard for me to say it always happens one way or the other. There are a lot of different ways that it can happen, but just know that you probably won't get sued, okay? Like they will probably just tell you to take it down. And or if you've been making some money on it, they're gonna want a cut of the pie. But if you get a letter like that and it sounds pretty spooky and scary, you should probably work with the LCA or call a lawyer. Okay. That was a really long-winded answer, but I hope it made sense.
No, incredibly helpful. Thank you. Yeah.
Hmm.
Thank you, TJ. We have a couple of more questions.
Yeah, 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 yeah.
Ryan, you want to hop off mute?
Hey, how's it going?
Hey,
Hi.
how's it going, Ryan?
Hey.
What do you got for me?
All right. So, I was, I guess, not even commissioned, or I shot a commercial for like a company around my house here, and just to show them my work. It was kind of an audition, like they just wanted to see my work and see if we could make future work together. They chose to go in a different direction because I guess our visions didn't match, but I'm still very proud of the work I created. So I'm wondering who owns the right to that work. Like I did use some of their resources. It was a car detailing company. So I used one of their cars and I shot on their location. But I'm wondering like, am I able to share that professionally or on
Oh
social
man,
media?
this is such a good question. Oh man. All right. Good question, man. Really good question. You didn't sign
Thank
any
you.
paperwork with them, right?
None. It was all through
None.
text messages.
None. Copyright is the property of the human author. You own it, man. You own it. They own zilch. They own zilch. All right. Let's talk about like something else, okay? This is a great example. So of like another tall tale. You know how I was talking about tall tales before? This is like another tall tale you'll hear repeated in the entertainment industry. People will be like, well, like, these are my songs, but I don't own the studio. Do I still own my songs? Or the label or somebody else, right? My mom paid for my studio time. Does the studio own my songs? Does the label, like, does my mom own my songs? Like, how does this work? No, like, none of that's true. The person that wrote those songs, they still own the songs. The person that shot that footage, you still own the footage. Okay? That is your property. Really good question. Really good
Thank you so
question.
much.
Hmm.
Thank you, Ryan. Maria P. She has a couple of questions.
Hi, can you hear me?
Yes, we
I can hear you,
can.
Maria.
Hi. I have two questions. One is regarding like filing costs. What are like the typical filing costs for like copyright registration or like trademark?
Great question. Okay. And
I'm
I
sorry if
was
you said that before, okay?
no, no, I did not say it. I was gonna go into it next. So I'm just gonna kind of talk about this slide. Okay, so I'm going to start with trademarks. Okay, trademarks, you can register trademarks in the state that you live in, or you can register them federally. State copyrights are probably only going to be like, I don't know, like 50 to 70 bucks. They're pretty cheap, but they only protect you in the state. A federal trademark, they usually run you around 200 bucks. And, that's just for one trademark. Sometimes you want to trademark something in more than one space. Like, let's talk about Apple, right? Apple has definitely trademarked the word Apple in the computer space, but they've probably trademarked it in the phone space too, and in the digital, marketplace space, right? Those are probably three different trademarks. So one can become three or four pretty quickly. What should you do? If you're like a pretty local business, like a diner or like a laundromat or something like that, you only have trademarks in like the state of Illinois, or excuse me, you only have business like in the state of Illinois. You can probably just go with the Illinois trademark if you want it. But if you do business across state lines, in just one state, if you're sending goods all over the state, you're gonna want the federal trademark. You're just gonna have to go for the federal trademark, 200 bucks. Copyrights thankfully are much cheaper. Copyrights, and it's been a little bit since I've looked at it. It's similar to the state trademark price. It's like 45 to 60 bucks, somewhere in there, with the federal government. And, again, though, that can add up too. You got 12 songs on a record, 50 times 12, whatever that is. So yeah, they can range from fairly cheap to, not so cheap if you were looking at a pretty big federal trademark. Does that answer your question?
Yes, this is my other
Great.
question. Let's
Yeah,
say if I create something and then 10 years later, I'm like, wow, this is so important. Uh, if I register something, that piece, like years later, will it still be like fully protected?
good question. So let me get this straight. Like, let's use a trademark as an example, right? Well, okay, wait. Let's start with the copyright because that's easier. Life of the author plus 70 years. Yeah, so if you register it, you're good. You're good for your whole life. Trademarks work a little bit different. So if you register your trademark right away, like or the first time, okay, let's say the first time you register your trademark, this I'd have to double check, but I'm pretty sure the protection lasts for like 4 or 5 years, something like that. And then if you forget about it for 10 years, yeah, your trademark has expired. Um, the next time you register it, though, if you register it in time, you get 10 years of protection. So that gives you a longer runway. What happens if your trademark expires? There are ways to revive trademarks depending on how long ago you let it expire. In the situation we're talking about, okay, this thing has been expired for 4 or 5 years. I don't think they're going to let you revive it. I'm like 99% sure they don't let you revive it. You're going to have to just file a new trademark. Um, Usually reviving trademarks are more expensive anyway, so you probably just want to go the new trademark route.
Thank you so much.
Of course.
Thank you, TJ. We're
Mm,
almost out of time.
Okay.
So if you have any last words to share with us, please do.
Yeah, I do. If you're an artist, look at all these business structures I have listed here, okay? Just make an LLC, okay? Just make an LLC. That is going to be the best situation for 99% of you, okay? That's one. Two, when you have contracts, okay, for your art, the whole contract is going to be important, okay? But here are the sections you really want to pay attention to, okay? Grant of rights. So you own the art, right? What are you allowing me, the business owner, to do with your art, okay? The grant of rights section is going to tell me what I can do with it. That's very important. Compensation. We all want to know how we're getting paid, right? And art pay can be weird. Sometimes you're getting money up front. Sometimes you're only getting royalties. Sometimes you're getting both. Sometimes you're getting an advanced against your royalties, which means I'm going to give you a big, bag of cash up front and your royalties are going to pay me back. Okay. So know how you're getting paid. It's very important to understand how you're getting paid. Ownership. Who owns the final product, right? That is so important. Are you going to own this? Is this an assignment? Then you're not going to own it anymore. Is it a license? Then you're going to keep owning it, right? But just no ownership. Know if you're doing a license or an assignment, please. Very, very big. Indemnification. This is the last section. I'm just going to explain this with an example and then I'll be done. I know we're at 3 o'clock. Sorry, guys, but this is really important too. So here's how indemnification works, and I'm going to use the music industry, okay? Um, let's say you're an artist and I have a movie and I want to put your song in my movie. I'm going to write a good indemnification clause, which is going to say this. I'm putting your song in my movie. You are promising me that this song is original and you are the only one that owns it. If that turns out not to be the case and I get sued for copyright infringement by somebody, you are going to pay all my legal costs because you promised me in this indemnification clause that you were the owner and you are a liar, and I don't like liars. That's how that clause is going to work, okay? 3 o'clock, I'm going to give you guys the rest of your day back. I really appreciated speaking with you. If you thought this was interesting, I speak on the music industry and the entertainment industry pretty much every day on TikTok. Give me a follow there. If you want to send me an email and tell me I'm ugly or something, go ahead. There's my email address. And if you want to learn more about the Lawyers for the Creative Arts, there's the Lawyers for the Creative Arts website, law-arts.org. I would be happy to talk to you about the LCA. I'd be happy to talk to you about anything else. Check out the LCA's website. They have a ton of great resources for artists. Thank you again for your time today, guys.
Thank you, TJ, so much. Stay on the line with me if you can.
Okay.
Bye, everyone. Thank you so much for joining us today.